And those take us to really the issues of people being fired for what they post on the internet. I've got a picture of the dislike button there, which doesn't actually exist. But and these cases are also relatively new. I've put a clip again here of a news story out of Ottawa that was posted on Canada.com back in 2007. A grocery store called Farm Boy. Some of the workers at this grocery store started a forum on Facebook called I Got Farm Boyed, where they were posting things about how they didn't like the price of milk at their grocery store and various other complaints. Seven of them were fired as a result of this post. I don't have further details on this one. There's no reported decision. But the types of things that really get you into trouble here, and I've just given a few examples. I hate my boss. You shouldn't post that on Facebook. I was late for work again today. I just can't get out of bed. I shouldn't have to work so hard. My company is bad and people should not purchase its wares and or services, which is perhaps a bit generic, but you get the idea of what kind of post could come out of something like that. Other things you shouldn't post are pictures like this guy. This guy was fired. This was a bank intern in the United States, and this is one of the early Facebook firing cases. Some of you may remember this. I remembered it in preparing this presentation as soon as I saw the picture. He told his boss that he had a family emergency and had to go out of town. Apparently his family emergency was dressing up in a Halloween costume and drinking beer, so they found this picture of him on Facebook and let him go. But some of the reported decisions, and the first one that I'm aware of that came out in Canada is a 2007 decision involving a Mazda dealership in British Columbia. And this is an arbitration decision, but there were a couple of employees of this Mazda dealership, which had been recently unionized, who were critical of some of management's ways of running the business, if I can put it that way, and decided to post things about it on Facebook. And I've given a couple examples here. The first post is, sometimes you have good smooth days when nobody's blanking with your ability to earn a living, and sometimes accidents do happen. It's unfortunate, but that's why they're called accidents, right? And later, this employee posts, completely exploded and snapped on the fixed ops head blank at work today. He sent me home with pay and wrote me up. Strike one. Although the blanking gloves are off now, I gotta control my temper. One strike in 4 years ain't bad, I guess. In the context of what these gentlemen posted, this is some of the more tame stuff, I guess I would characterize it. You can read the decision if you're interested, and feel free to email me and I'll send you a copy. There were a variety of posts like this, and both employees were dismissed. They grieved the dismissal, but the BC Labour Relations Board upheld it. And part of the issue, of course, is privacy. Both of these employees had restricted access to their Facebook pages. The problem that the BC Labour Board found with the argument that the postings were somehow private was that one of the employees had 100 friends on Facebook, the other one had 300 friends, and in both cases they included co-workers from the same business. So the arbitrator said that the employees could not have a serious expectation of privacy when publishing comments on their Facebook website. A more recent case, which has attracted a fair amount of attention in the legal community, is a decision involving a Canada Post employee at a depot in Edmonton. And she had worked there for more than 31 years. She had a couple supervisors she didn't get along with. There was Supervisor M and Superintendent D. She was generally critical of both of their management styles, in particular this Superintendent D. And issues erupted in 2009 when there was a meeting called to address productivity concerns. None of the employees were happy, and that's important. We're dealing with this situation. One of the things that makes this case sort of unique is that you're dealing with an employee who's got a very great length of service and legitimate concerns about what's going on in the workplace. There were a number of altercations between employees and staff, issues with swearing at one another. There was a 3-day suspension handed to the disgruntled employee, the postal worker of 31 years in this case, and 3-day suspension. What she decided to do with that time and some of her other time was post comments on Facebook. So the comments were actually discovered by Superintendent D. She didn't know how to use Facebook, so she asked Supervisor M to find them for her. But they found 26 postings from 14 separate occasions. And the comments included the following. Up and drinking again. 3 nights of freedom from postal hell. Die blank die. I'm playing with this Superintendent D voodoo doll. If I wasn't drunk, I would take it out to the driveway and run the blank over. And it's surprising when you read the decision, you find out that not only was she making this up, she really did make a voodoo doll of her boss, which is really disturbing. The latter of the post, and again, there are a lot of these. We surprised Evil D by showing up for work. She brought in 4 casuals and an injured letter carrier and had the 2 DAs come in 2 hours early. Employee S told us she told them on Friday we weren't going to show up. Wrong again, blank. You gonna be the one missing permanently. You can understand how an employer would be legitimately concerned about seeing this on Facebook. Once they were discovered, of course, she was suspended. Both of the employers at issue, or the managers, missed time from work because they were distraught. And surprisingly, the griever was somewhat unapologetic. And again, this is dealing with a situation where you have other employees who are disgruntled as well. So she was dismissed after 31 long years. At the hearing, the employer argued that these postings were grossly insubordinate. The union, on behalf of the griever, argued that they were provoked by a toxic work environment and that the dismissal was too severe. Now, the griever was also under the impression that the postings were private and that she had no intention of making them public. The problem is that she didn't have her privacy settings on, so they were quite public and everyone could read them. In any event, her grievance was dismissed. She was terminated with cause after posting these things about her supervisor. Provocation was no defense. It's grossly disproportionate to threaten to make a voodoo doll out of your supervisor and run it over with your car, no matter what has gone on in the workplace. Also, the degree of misapprehension about who could access her Facebook was not a defense in this case. As with the Mazda case, you're dealing with someone who's got coworkers and friends on Facebook, so notwithstanding the fact that her profile was public, it could be viewed by other people who were working with her. The arbitrator held that the current case is unprecedented in the repeated mockery, the threatening language, the vile insults, and the debasement of an identifiable manager. So grievance dismissed. Now I'm just coming to the end here, and I just want to mention quickly one other case. It's not always the case that where you post something offensive on Facebook, you can be dismissed for it. And this was a case involving a pilot at Wasaya Airlines who worked there for 3.5 years. And there were no issues really in the workplace, but his post was, you know you fly in the north when, and then he had a list of 10 items which were racial in nature. Now I haven't reproduced these here because I actually don't know what they are. They weren't reproduced in the arbitrator's decision at the employer's request because they didn't want this information publicly disseminated. But suffice to say that they were racial, and you can probably imagine to some extent what they were, given that we're dealing with an airline that's a First Nations airline, services First Nations communities in the north. Now the union in this case accepted that there was cause to dismiss, but you're not dealing with one of these cases where you've got threats being made against a supervisor and all kinds of provocative and foul language. And so the decision was that discharge was excessive in the case. The conduct did have a potential for a detrimental effect on the company, Discipline was indeed justified, but not discharge, which is, of course, the most extreme form of discipline. So the result was, as per Bill's presentation, pay in lieu of notice. And the way this is affected in this case is that the griever is simply suspended for 4 months with pay and forced to resign at the end of that 4 months. So not all Facebook postings which are offensive are going to give rise to termination. The moral, of course, is that the employee can be disciplined and even fired for posting damaging work-related statements on Facebook, even if they're posted outside of work hours, in the bathroom perhaps. The internet is a fundamentally public place. And so the message, certainly for employees, but generally for all of us, is to think before you post. You never know who's going to read it and what it's going to be used for. Thank you very much.